We've been looking for Elizabeth Smart for some 9 months, and she's with you. And we're very curious as to how that all came about. But as far as we're concerned, it's a crime. I'm going to be up front with you right off the bat. We believe you committed a crime. And you have certain rights that we have to advise you of before we can talk to you. Okay? You have the right to remain silent. You understand that? Anything you say can and will be used against you in a court of law. Do you understand that? You have the right to talk to a lawyer and have him present with you while you're being questioned. Do you understand that? If you cannot afford to hire a lawyer, one will be appointed to represent you before any questioning if you wish. Do you understand that? You can decide at any time to exercise these rights and not answer any questions or make any statements. Do you understand that? Okay, do you understand each of these rights I've just explained to you? Have your rights in mind, will you talk to us and answer our questions?
You have the right to remain silent. Anything you say or do can and will be used against you in a court of law.
This phrase, made famous by many movies and TV shows, defined by many court cases, started with one, Miranda versus Arizona. The Miranda case, which was eventually argued on appeal before the Supreme Court, was centered on Ernesto Arturo Miranda, who confessed to the crime of burglary and the rape of Louis Ann Jameson without knowing his Fifth Amendment right and with false information given by police that Miss Jameson had positively identified him as the culprit. Chief Justice Earl Warren stated in the defense of the court's decision on Miranda,
Life and liberty can be as much endangered from illegal methods used to convict those thought to be criminals as from the actual criminals themselves.
Although the 1966 Miranda decision of the Warren Court was an attempt of the Supreme Court to assume the responsibility to equalize Americans and help the underprivileged maintain their legal rights during the Civil Rights Movement,
Today, it has had an unintended negative impact on society by helping wealthy or experienced suspects who know how to manipulate the system,
while creating a disadvantage to those least experienced,
thereby contributing to a system dramatically slanted against the poor and minorities.
Miranda's lawyer appealed the case on the grounds that Miranda did not understand that he had the Fifth Amendment right against self-incrimination. Miranda's conviction was overturned in the Supreme Court's landmark ruling in 1966. Prosecutors later retried the case using other evidence, and he was again convicted. Miranda served 11 years in prison and was paroled in 1972. At age 34, Ernesto Miranda was stabbed and killed in a 1976 bar fight. A suspect was arrested in Miranda's stabbing, but ironically, exercised his right to remain silent and was released without being charged. Supreme Court Chief Justice Earl Warren felt it was the court's responsibility to provide help for impoverished African Americans who had been discriminated against so much historically through Jim Crow laws enacting racial segregation between 1876 and 1965 at the state and local level.
Before the warning was constructed, the accused were being ruled over by lawyers, policemen, and even judges. David M. O'Brien writes, "The Warren Court revolutionized constitutional law in American society. First, the unanimous and watershed school desegregation ruling, Brown v. Board of Education, in 1954, then in 1962, Baker v. Carr, guaranteeing equal voting rights to individual voters no matter where they lived. And throughout the 1960s, the court handed down a series of rulings on criminal procedure that extended the rights of the accused and sought to ensure equal access to justice for the poor. Mapp v. Ohio, extending the exclusionary rule to the states, and Miranda v. Arizona, sharply limiting police interrogations of criminal suspect."
When a person is not properly Mirandized, certain evidence cannot be admitted in trial, and they are often released.
Prior to the Miranda decision, it was generally thought the Fifth Amendment was limited to courtroom type proceedings. In other words, a criminal defendant could not be forced in a criminal trial to testify. But prior to Miranda, the Supreme Court decided a case called Escobedo versus Illinois. In Escobedo, the Supreme Court applied that amendment to a situation where a defendant had not yet been formally charged, but was being questioned by the police.
If a lawyer, as you say, he's entitled to a lawyer under the facts of Escobedo, and the lawyer is entitled to tell him that he doesn't want him to talk to the police, why would it be a menace for another lawyer to do the same thing.
Mr. Chief Justice, I'm not disagreeing with you one iota. I am just saying that if, in effect, that this is what should be done, if you want to equalize, for example, the defendant's right against the policeman, naturally he should have counsel, if this is what we are striving for.
Well, suppose we put it on the basis of not equalizing anything or balancing anything, but on protecting the constitutional rights of a defendant, not to be compelled to convict himself on his own testimony.
Mr. Chief Justice, I, of course, do not interpret the Constitution. This is, of course, your prerogative.
The Warren Court did not anticipate that the decision would contribute to a system that creates a disadvantage to those least experienced while helping wealthy or experienced suspects who know how to manipulate the system to their benefit. Legal scholar Richard A. Leo explains.
A suspect with a felony record in my sample was almost 4 times as likely to invoke Miranda as was a suspect with no prior record. This result confirms the conventional wisdom among the detectives I studied who complained that ex-felons frequently refused to talk to them as a matter of course. The more experience that a suspect has with the criminal justice system, the more likely he is to take advantage of his Miranda rights.
Paul G. Cassell explains.
The Miranda rule gives sophisticated suspects, mainly recidivists and white-collar defendants, the ability to lawyer up and avoid questioning altogether.
Brian Reed writes,
For the past 3 decades, I've sat in courtrooms and despaired at the warped bias at the heart of our justice system. I've covered cases where professionals have escaped with lenient sentences because a judge bought into the almost Masonic view that they were one of us, respectable, hard-working, middle-class people who didn't deserve the indignity of being locked up with society's riffraff because perjury, fraud, tax evasion, or perverting the course of justice was a white-collar crime.
The Miranda rights have given more attention to litigation of procedural issues rather than investigation into a correct conclusion on the issue of guilt or innocence. More emphasis is placed on procedural due process than substantive due process, giving those with the most skilled attorneys a significant advantage. In The Collapse of American Criminal Justice, William Stuntz, a Harvard law professor, writes,
The last half of the 20th century saw America's criminal justice system unravel. Signs of the unraveling are everywhere. For black males, a term in the nearest penitentiary has become an ordinary life experience.
Stuntz argues that the American justice system isn't doing its job well. It's not producing justice, avoiding discrimination, or protecting those who most need the law's protection. Stuntz explains that
while only 10% of the adult black population uses drugs, as does roughly an equal percentage of the adult white population, blacks are 9 times more likely than whites to serve prison sentences for drug crimes.
Similarly, in response to a recent 2010 Supreme Court ruling which diminishes the right to remain silent to those who actively request it,
Harvard law professor William Stuntz, a conservative, had this take on the decision.
The doctrine makes no sense. It provides lots of protection to suspects who don't need protecting, to the best educated and to recidivists who know how to game the system. And it provides no protection to the people who need it most.
Many African Americans continue to express a lack of trust in the system. In 1970, Gil Scott Heron declares, "And the revolution will not be televised."
There will be no pictures of pigs shooting down brothers on the instant replay. There will be no pictures of Whitney Young being run out of Harlem on a rail.
In 2013, rapper Jay-Z and Picasso Baby
They try to slander your man on CNN and Fox. My Miranda's don't stand a chance of cops.
Also in 2013, President Obama spoke on this historical lack of trust many African Americans have in the criminal justice system, as evident by their reaction to the verdict in the recent Zimmerman case.
The African American community is looking at this issue through a set of experiences and a history that doesn't go away.
The Miranda decision's positive impact was transitory. Political scientist Troy Smith explains that this is to be expected.
The assumption is it fits for a large part of our society, is that we can get something right. it's kind of like this scientific idea that if we get it right, then that will be it, and that will be the thing that lasts forever. But I think we need to realize that in human societies, people are constantly learning, adapting, adjusting, and changing. Things are never perfect. You could get something perfect, but people are going to adapt and adjust and change to it.
Stunts does not suggest repealing Miranda, rather argues that voters and legislators should take action to minimize those injustices. Stunts believes that
putting more police officers on city streets should reduce both crime and the number of prisoners. Judicial interpretation of the 14th Amendment Due Process Clause should endorse the broad view that no class should be punished more severely for its crimes than another, and judges should have greater discretion to limit the severity of punishment for the possession or use of drugs, which would reduce discrimination against the black defendants.
Supreme Court Justice John Paul Stevens has responded to Stunts' assertions, suggesting that while the Miranda ruling has had unintended consequences, it was still clearly correct. Justice Stevens quotes Chief Justice William Rehnquist in his opinion upholding Miranda a decade ago, explaining that the case
has become embedded in routine police practice to the point where the warnings have become part of our national culture.